The IDEA, the Individuals with Disabilities Education Act, guarantees children with disabilities a free, appropriate public education. Appropriate education is not defined in the IDEA, and so this question of what an appropriate education is has been an issue in controversy since the IDEA was enacted in 1975. The case that I had back in 2008, Thompson School District versus Luke P., was a case where the 10th Circuit for the first time addressed what is an appropriate education? What is a child with a disability entitled to, as far as an education goes, in public schools? Judge Gorsuch authored the decision that an appropriate education means merely more than de minimis progress on some goal. That is merely more than nothing. I was devastated, and I felt responsible for, this standard now being the law. 3 years later, this Endrew F case presented itself. Here's a case that doesn't even rise to this level of merely more than de minimis. This kid, Drew, with autism, had had an IEP since he was in kindergarten. An IEP is an individualized educational program, and within that IEP, the parents in the school district collaborate to put together, here's what you're going to be working on for the year, and here's what we hope you achieve by the end of the year. But in second grade, the parents noticed that Drew's behaviors started deteriorating. In conjunction with deteriorating behaviors was sort of inability to learn. In third grade, it was getting worse, and then, in fourth grade, sort of the bottom fell out. When it came time to gather everybody together to say, all right, how's Drew doing, and what are we going to do for fifth grade, the school district didn't have any answers to his, behavioral problems. They hadn't tried to assess that, and the parents were like, we're done. We have a short window of time to get our child to be a productive member of society, and we believe he has the potential to do that, but you're not doing it. You don't get it, you haven't figured it out. So they enrolled him at their own expense at a private school specializing in the education of children with autism. And under the IDEA, the parent is entitled to request payment for that private school if the parents can establish that the school district did not provide their child a free, appropriate public education. They tried to get the school district to understand what this child needs, and the school district said, under this Luke P standard, all our requirement is merely more than de minimis progress, and here we believe he's making progress in this one area, and therefore we don't have to do anything more. And so we filed a due process complaint. Well, the administrative law judge said because some of the objectives were harder than the previous objectives, even though there's no evidence of any progress on any of these goals and objectives, that signaled that Drew was making some progress. And so school district wins, parents lose. We appealed that to the U.S. District Court. Again, he ruled in favor of the school district and against the parents. We decided we're going to continue to fight. And significantly, the 10th Circuit did recognize that there are circuits out there that provide a higher substantive level of education to children with disabilities than they do in the 10th Circuit. But because we have to apply a merely more than de minimis standard, we're constrained to find in favor of the school district. So again, the school district prevailed. Within a day, I started getting these calls and emails from various law schools, various law firms who wanted to co-counsel on this case and take this up to the U.S. Supreme Court. This case was striking at the heart of the guarantees of the IDEA that had been in flux for 35 plus years. On March 22nd, 2017, the Supreme Court issues this decision that is a game changer as far as the rights of children with disabilities. I think what's really important about this case, not only the result, but the timing of this decision. In that period of time, the president nominates Judge Gorsuch to be his new Supreme Court justice. And as soon as I started going through the decision, started getting these texts and these calls, you need to get on C-SPAN. You won't believe what's going on. Somebody had walked this decision, this Endrew F decision, over to Judge Gorsuch's confirmation hearing and distributed it there. Senator Dick Durbin from Michigan was basically interrogating Judge Gorsuch about his standard, but also the Supreme Court's staunch rejection of that standard. And why did you add this word merely to this standard of more than de minimis? It did sort of publicize to the country or to the world that children with disabilities cannot be treated this way under the law, that they are entitled to a markedly more demanding standard for an appropriate public education. I would like to thank CTLA for nominating this case as Case of the Year and recognizing how transformational this case is to upwards of 6.6 million children with disabilities and the impact it has made and it will make for all children.